Hello everyone, my name is Alice Wanamaker. I'm a dual enrollment student at Holyoke Community College, but I created this project with the mentorship and support of Professor Diane Curtis at UMass Amherst. My project is titled Missing Right, Construction of an Affirmative Constitutional Right to Vote. It proposes a constitutional amendment that would guarantee the right to vote to all U.S. citizens. My research came in 4 parts. First, I studied the political theories that make the right to vote important. Next, I researched current forms of disenfranchisement in the U.S. and why they are philosophically not acceptable. Third, I analyzed the legal arguments and doctrines that have led to the Supreme Court to allow these types of disenfranchisement so far. And finally, I proposed an amendment with language strategically written to counter these legal arguments, and compared it to other proposals for voting rights amendments, which I found to be written a bit less strategically. I'll begin by describing the philosophical arguments for the right to vote, many of which are the same philosophical arguments that were used to create the Constitution in the first place. John Locke's social contract views the government as an agreement between the people and their leaders, in which the people agree to be subject to laws in exchange for the services the government provides. Social contract theory requires people to be enfranchised because it says that the government can only make laws controlling people who agree to be governed, and voting is the mechanism by which people agree to the social contract today. There are some practical exceptions to this. 2 examples are young children and tourists, 2 groups who should probably be subject to U.S. law and probably shouldn't be enfranchised. However, the basic premise still stands. Unnecessarily disenfranchising people makes the government's jurisdiction over them illegitimate and unjust. The other concept I found to justify a right to vote is self-determination, which has been used very effectively throughout U.S. history and describes why voting is useful. The summary of self-determination, which was articulated by political scientist Robert Dahl, is you best represent yourself in government. This means that enfranchising a demographic is a method of advocating for their interests. Historically, expansions of suffrage have coincided with political actions that furthered the interest of the newly enfranchised demographic. The first Black representatives in Congress were elected in the 1870s in the midst of the Reconstruction Amendments being passed, and public health and education outcomes in the South drastically improved in the 1920s after white women were enfranchised by the 19th Amendment. As I'll describe momentarily, U.S. disenfranchisement disproportionately affects several demographics, including Black people, low-income people, and young people. These groups are obviously very different, but all 3 have political interests that could be furthered if they were able to put increased pressure on the representatives by voting in larger numbers. In today's political climate, voting is a social justice issue. So now that we know why voting is important, let's go who's being disenfranchised in the US today and why they shouldn't be. The most pressing issue I found here was felon disenfranchisement. Around 5.2 million people are currently disenfranchised due to a felony conviction, over half of whom had completely finished their sentences. Disenfranchising felons is a clear violation of the social contract, because the government doesn't have the right to impose legal consequences on someone who isn't able to approve those consequences by voting. Self-determination is also at play here, as many disadvantaged groups, especially Black people, are disproportionately incarcerated in the U.S. Next, voter ID laws, which require people to present a photo ID when they vote, are a second issue. 36 states currently have this type of law. Because the process of getting an ID almost always costs money, voter ID laws function as a poll tax, a historically discriminatory method of disenfranchisement which was banned in its pure form by the 24th Amendment. Black, Hispanic, and low-income voters are also less likely to have these types of IDs, meaning that these laws serve as a check on those populations. Finally, voter ID laws don't appear to have a significant impact on election security. No studies have proven that voter fraud is a significant issue in the U.S., or that voter ID laws decrease voter fraud. If a law stops some people from voting without meaningfully increasing election security, it's unnecessary disenfranchisement, and that's unacceptable. Voter registration practices are a third issue, and probably the most diverse. Registration looks different in almost every state, and many issues in the registration process affect how many people are able to vote, from registration deadlines to registration locations to the circumstances under which people are unregistered. These processes are a concern because they have the potential to be unnecessarily restrictive and disenfranchise people without cause, which is, once again, a major problem. And then the final issue I address here is the voting age, which is currently 18. The problem here is that there's no scientific evidence that 18 represents a change in a young person's development that newly qualifies them to vote. Some studies show that brain development is not concluded until the mid-20s, while others argue that the specific parts of the brain used to vote are mature by the mid-teens. Either argument places 16 and 18-year-olds in the same category of preparedness, meaning that the distinction between them is arbitrary and not legitimate. Teenagers are subject to laws, meaning that unnecessary disenfranchisement harms the social contract. We also have demographic-specific political interests, such as climate change and education policy. In summary, today's disenfranchisement issues unjustly remove people from the social contract, thereby removing the government's jurisdiction over them, and prevent disadvantaged communities from utilizing self-determination to further their interests. So, now that we've discussed how these restrictions are problematic, let's talk about the legal structures that allow them. Understanding the specifics of problematic voting rights jurisprudence, let me write an amendment designed to effectively counter it. Felon disenfranchisement and the voting age of 18 are both explicitly allowed by the Constitution. Section 2 of the 14th Amendment allows felon disenfranchisement, and the 26th Amendment sets the federal voting age at 18 as opposed to 21. These provisions are clear and easy to interpret, so they won't be changed by a court case interpreting the Constitution in a different way, but they can be changed with a new constitutional amendment saying something different. Voter laws and strict registration requirements are also legal, because of Supreme Court reasoning rather than explicit wording in the Constitution. The most important argument here is found in Crawford v. Marion County Board of Election, a case specifically reviewing a strict voter ID law in Indiana. Crawford ruled that this law was legal because it furthered the government's interest in preserving election security, even though there was no data showing that the law preserved Indiana's election security. The court also declined to use the standard of scrutiny that's typically used to protect the most important rights in the U.S., strict scrutiny, which would have required that laws restricting the right furthered a compelling state interest and be written in the least restrictive manner possible. So, in a summary of Crawford, states don't have to prove that their election laws preserve election security in order to justify them. They just have to prove that their laws are intended to preserve election security. And by not using the least restrictive manner rule, they contend that voting laws can be written in a way that's more restrictive than absolutely necessary. That is the state of voting protections in the U.S. today. This reasoning was created by the Supreme Court, so it could be overruled with another court case, but it's impossible to predict when or whether the court might change its mind. The more certain solution is a constitutional amendment requiring a new interpretation of voting law. In conclusion, a constitutional amendment is an effective strategy to solve all of these problems, so I wrote one. Here's the text of my proposed amendment. All citizens of the United States who are 16 years of age shall have the right to vote in any public election held in the jurisdiction in which the citizen resides. The right to vote shall not be denied or abridged by the United States, any state, or any other public or private person or entity, and Congress shall have the power to enforce this article by appropriate legislation. So here's what it would do. First, it changes the voting age to 16. Next, it explicitly guarantees the right to vote in the Constitution, which is intended to trigger the Supreme Court to apply strict scrutiny when reviewing laws that restrict it. It also includes a list of the entities that are banned from restricting the right to vote, because constitutional rights normally only limit the federal and state government, and I also wanted to prevent private businesses from disenfranchising people if they wanted to do so. Finally, although it doesn't explicitly say so, it will overrule the provision of the 14th Amendment that allows felon disenfranchisement, because it changes the constitutional status of the right to vote. I justify the strength of this specific wording by comparing its potential interpretation by the Supreme Court to the potential interpretation of other amendment proposals on the same topic. Here are two. This 2003 proposal by Representative Jesse Jackson was the most influential to my process. You may notice that I used its language about public and private entities because I found it to be extremely clear. The main difference in our proposals, besides the voting age, is the disclaimer Jackson included at the end, except that the United States or any state may establish regulations narrowly tailored to produce efficient and honest elections. Both Jackson and I understand that some laws will have to restrict voting a bit in order to produce efficient and honest elections. But I didn't write an exception for this, because the Supreme Court will create their own. Many other rights, like the right to free speech, are written in the Constitution that they cannot be abridged, and the Supreme Court has chosen to abridge them when it's absolutely necessary. A disclaimer might allow limitations when they aren't absolutely necessary, so I didn't include one, which makes my amendment proposal protect the right to vote a bit more strictly than Jackson's would. This is a more recent proposal, introduced in Congress in 2017 by Representative Mark Pocan. The main difference here is the use of the word fundamental. Both Pocan and I would be happy to see the Supreme Court declare voting a fundamental right, which is the process that usually triggers strict scrutiny. But I chose not to use the word fundamental for several reasons. First, the other rights declared fundamental from the Constitution don't say fundamental, and my amendment's intent to be a fundamental right is clear even without the word. Second, the fundamental right doctrine isn't written in the Constitution. It was made up by the Supreme Court and could be thrown out in the future. My amendment establishes a constitutional basis for strict voting protections, independent of any Supreme Court doctrines. It creates its own standard, and therefore it's likely to be a bit more stable than Pocan's proposal. The right to vote is crucial to preserve the legitimacy of our government and allow U.S. citizens to effectively advocate for their interests. A constitutional amendment both recognizing the necessity of suffrage and explicitly guarding against today's known methods of disenfranchisement gives us the opportunity to reach a legitimate state of moral governance, a desirable, ethical, and entirely new phenomenon. The language of the amendment I crafted is designed to counter disenfranchisement as effectively as possible, and I believe if ratified, it would have a profound effect on the nation. Thank you.